Marshall, are you ready to go live? Marshall,
He is
we're
not.
live, by the way. Just so you're aware.
I apologize.
No, that, it's fine with me. I just wanted you to know you're live.
I've been willing to say things live, I don't mind that. I do apologize for interrupting you.
All right, we're going through S6 with Michelle.
Good
And that's
morning.
the custodial interrogation bill.
Right. So I'm zooming in because I think it's going to be
He's
easier.
subbing for Ben, who is out with Jacob.
Yes. And
Jacob is the new son,
He's very cute.
by the way, yeah. So,
so I'm zooming in so I can share my screen and you can see both versions up there. So I'm going to do that and walk you through. Can you see both documents?
no,
No. Okay.
both documents.
Well, Shadi showed me how to do this.
Wow, I'm impressed.
We thought it was working. Hold on 1 second, sorry. Dang it. Let me try one more time, sorry.
Whoops. That was just a little.
Oh, well, I'm sorry, I can't do that. It's just going
No
to
problem.
one.
We'll get through it.
Okay,
I suggest you leave that one. We're on 3-1. We have a copy right here in front.
Yeah,
of
we have a copy in front of us.
Yeah, maybe
Michelle.
put
Why
the
don't
old
we
copy.
Put the old copy
that?
up there.
Yeah.
so do you want me to have the Senate version? Well, no, I think I want to go through the other one. So let me do that and
Isn't technology wonderful?
Until it's not.
I thought I had learned a new trick, but I guess not. How's that? And then we can toggle back
That's
to
better.
the Senate
Well,
one.
that's
if
the
we
one we
need to.
have.
Pardon?
That's the one we have, Michelle.
Yeah.
We wanted to put the other one up, but you wanted to put side by side with it.
Right, I'm just having it shows up on my screen, but I'm having a hard time sharing with them both next to each other. So, so if it's okay, I'm gonna go through the House proposal of amendments, and then I can go back and show you in those how yours is different. So we're taking a look at version 3.1, and I think you know it was voted out of House Judiciary yesterday, and we'll be going to appropriations because they've added back in the appropriation that Senate Judiciary had included originally that was removed by Senate Appropriations. And so it still has another stop in the House before it goes to the floor. So the first change is that the House added a new section 1 for legislative intent. And then I'm just going to go over and just show you, I've highlighted things that it's not so much specific language, but changes in policy. There's no changes in section 2 or in section 3 regarding the electronic recording of a custodial interrogation. And so the next changes are in section 4. So looking at their version on page 6, you'll see that if you'll recall in the Senate version, what you did is you created a the folks who are less than 22 years of age, who, and then you had in this beginning language, you combined threats, physical harm, or deception. And so what the House has done is, because threats and physical harm are not permitted, and they are by their very nature inadmissible, they have put that, they've carved out into different subsections how threats and physical harm are treated, and then how the use of deception for under 18 is addressed, and then how deception to a person who's 18 to 21 is addressed. And so,
Michelle,
sure.
I'm sorry, did you say that the definition of threats is addressed in here?
Well, if you see section 4, subsection A, subdivision 1,
Mhm.
you see the highlighted language shall not employ threats or physical harm.
Yeah.
And so by the nature of that is that, so this would apply to any person, not just to under 22. And so there's a prohibition on the use of threats or physical harm for any person, and that if those techniques are used, then any admission, confession, or statement is involuntary and inadmissible.
So I think my question is, what, on line 10, what is considered a threat? If it, I guess my question is, if an officer is talking to somebody and they're saying, you could be looking at a felony if this case moves forward. Is that considered a threat?
So this language was in your bill as well. And I haven't been a part of the discussions until this week. So I wasn't privy to the testimony or discussions about that. I don't know whether or not Representative Chapin can address what was discussed in that context, but you also in the Senate version have language around threats as well. So that's not new.
Right. It's just something that I'm thinking about now. I thought we had a definition for what threats include in the Senate version, but I must have imagined that. So thank you.
Mm-hmm. So subsection B applies to a custodial interrogation of a person under 18 years of age. And so there is a prohibition on using deception. So B and C are dealing specifically just with deception, not with threats or physical harm. So you see B1 prohibits the use of deception for someone who's under 18 years of age. And you'll see subdivision 2 is that it shall be considered involuntary and inadmissible if it's used on kids under 18. Subsection C applies to the 18 to 21-year-olds. And you'll see there is that for that group, the use of deception is presumed to be involuntary and inadmissible. And so this uses the standard that you had in the Senate proposal. And so if you see the language that's on C2, this is your standard, the standard from the Senate bill of how the state can overcome the presumption that it was involuntary and inadmissible. So subdivision 2 is the same standard that you employed. Subsection D is new. And my understanding is that this language was added to ensure, and there's a later section that repeals subsection D after 9 months. But my understanding is that the House Judiciary wanted to have language in there so that it would be clear that if there is not a policy adopted, that it would not result in that kind of pendency period for an officer to be sanctioned for not having the policy. So Is somebody talking to me or?
I think that was in the hallway.
Okay. So section 5 on the Criminal Justice Council and the model interrogation policy, they added subsection A for some intent language. And then you'll recall in the Senate version, there were 2 dates that were set forth. So there was kind of like an interim period and then the later January 1st. And the House just combined it. So the rest of the language is the same in terms of it's the Criminal Justice Council in consultation with the AG, stakeholders, AHS, the League, and Human Rights Commission, and the Innocence Project. So again, they just kind of took out the intermediary step, but left the date the same for this January 1st. So the next changes are the position, as I mentioned. So section 8, page 12, adding the appropriation for Director of Policy within the Criminal Justice Council. Section 9 is the repeal of that earlier section that I talked to you about regarding sanctions against a law enforcement officer if there's not a model policy. And so this would repeal that language after a certain amount of time is given for them to adopt the policy. Those are the changes.
Okay.
Would you like me to pop up the Senate version?
No, it's okay. I think we-
Okay.
They seem pretty minimal.
Yeah, well, major. I wonder if anybody'd like to comment. Tucker, did you want to comment?
Sure, Chair Sears. I wasn't sure if you were speaking to the audience or just your.
I was, yes.
I just wanted to flag for the committee that this is a bill in its current form that the Department of Public Safety still has quite a bit of concern about. And we did submit a memo that you should have online that goes into.
You have that memo?
Yep, it's posted.
Okay. good.
Should be posted.
Why don't you run through that memo, Tucker, with your concerns?
Sure.
I
And
can say the concerns of the Department of Public Safety, not necessarily your personal concerns.
Yeah, so complicating this somewhat is that this was a bill that this committee got early on in the session and went through and passed out. And in the House, the testimony developed somewhat further regarding this concept of the use of targeted deception. So this group, unless you watched that testimony, this group did not actually receive the testimony from the detectives that explained how they use targeted deception in the field today. So these were detectives Drew Coda, detectives Ruth Whitney, also Matt Raymond from ICAC, and we also had Samantha Prince from the Windham County Special Investigation Unit. So as far as I know, your committee did not actually hear any of their testimony, but the House did. And some of those witnesses explained how they use targeted deception in the field today and their concerns about how this bill would impact their ability to continue using targeted deception, particularly the SIU cases, the Special Investigation Unit cases. So briefly, targeted deception would be deception under the definition of this bill. It would be the knowing communication of false facts about evidence. The common example that's given is in a sexual assault case, for example, with college students. So a detective may ask a suspect in response to a complaint of a sexual assault, they may ask a suspect if there had been sexual contact with the complainant, and the suspect may deny that there was any sexual contact at all. The detective may then use targeted deception to state that the complainant received a sexual assault exam, even if the detective knows, as a matter of fact, that the complainant did not do so. And they may say that and then posit the question of whether the suspect has any concern whether their DNA would show up on that sexual assault exam. The point of that form of targeted deception is intended to elicit a response by, for example, the college-age student of whether in fact there was or was not sexual contact with the complainant. So the suspect may respond, oh, well, actually there was sexual contact, but it was consensual. And that progression in the interview can be highly helpful to a sexual assault investigation. That's kind of one example of the use of targeted deception in this arena. Again, testimony that this committee did not receive in detail. There was also testimony from ICAC and their investigations of internet crimes against children. And as you'll also see, the Attorney General's office has submitted a memo, which I think you should have received too. So I think that gets on your website. Regarding their recommendations with the House version of the bill, in large part in light of their concerns from the ICAC angle. Matt Raymond testified that the 18 to 21 age range is one of the largest growing age ranges that they are seeing for suspects in the ICAC realm. So in sum, there's kind of growing concern that this bill, which would be the most expansive bill in the country, affecting the highest age range in the country. No bill, no statute in the country goes above age 18, will start to interfere with these investigations in serious felony cases. There is one example of this technique used in practice in Vermont, in a Vermont Supreme Court case called State v. Colts. That case regarded a detective using deception regarding a suspect's DNA in an aggravated sexual assault of a child, of an 11-year-old child. The result of the use of deception was a full confession from that defendant. And the Vermont Supreme Court went through its analysis and determined that it was voluntary and therefore admissible. Our concern is first that the standard that is in this bill to determine whether the 18 to 21 age range is going to be roll of the dice with real cases regarding what the court is going to expect in order to prove all of the prongs that are currently in the bill by clear and convincing evidence. That's the first concern. The second concern is that the provision that purports to provide some protection against professional certification sanctions actually does not do so, because it only protects against essentially unwillful or unintentional use of a violation of that section. But of course, the circumstances that we're describing of targeted deception are intentional. And so that's another concern. And the concern there is that there's going to be a chilling effect on law enforcement using targeted deception generally, not just because of the heightened burden in court, but because of the prospect that they will receive sanctions if they use that technique in the field. The third concern is that the model policy, it calls for the limitation and ultimate elimination of this technique statewide, and the policy applies to all ages under all circumstances, including non-custodial circumstances. So the concern there is that that will also have a chilling effect on law enforcement using this technique in the field. So that kind of sums up the extent of the concern. And we do have specific recommendations that the committee consider, along with the Attorney General's office's recommendations on how to bring this bill back to its original intent and to address the concern.
Before we start making changes, I feel like the two choices for us are either conference committee or adopt. I don't want to get into concur with further proposal amendment on this. We haven't had time to really take testimony on those sections that they added regarding 18 and 21-year-olds and some of the other. Michelle.
I just wanted to, and I'm sorry, because I'm just picking this up, but it sounds as though, am I understanding you, Tucker, that your concern lies with the 18 to 21-year-olds and the standard there, but that's the same as was in the Senate bill?
That's in part correct.
So you don't like that language in the Senate version or in the House version?
That's correct.
Okay, I just
so-
wanted to clarify that. Okay, thanks.
Marshall?
I'd also like to clarify, Attorney Anderson's correct that this committee didn't hear from some of the witnesses that the House committee heard from. And I would encourage this committee in particular to listen to some of the witnesses that Attorney Anderson suggested, like Samantha Prince and Ruth Whitney, who are investigators. And the questions that they were concerned about were not the questions that Attorney Anderson just said. The questions were not framed as, for example, we already got a sane evaluation. Now, is it going to reveal your DNA? Instead, the hypothetical question that Ms. Prince presented was, if we got a sane evaluation, what would it show? That's a fair question. That does not involve deception. There was concern on the part of law enforcement that that type of question would be considered deception, but it clearly does not fit within the definition of deception that's used here.
Senator Ash.
Thank you, Marshall. My question, and I guess just to clarify, did you mean Attorney Jones? You said Anderson?
I believe Attorney Jones.
Just wanted to clarify for the record, but
Apologies.
Attorney Jones, is there anything in at least VSP's rules and regulations regarding deception in the use of interrogation and interviews?
Not that I'm aware of. I'm not aware of a policy that governs the techniques or the methods that are permissible, but I don't know that definitively.
I'd like to clarify or confirm that because I mean, it's been a while for me, but as best as I can recall, I remember being told when I was a trooper that you can't lie to people when you're interviewing them. But that's kind of a distant memory. So I would like to confirm or clarify that if possible, because I could be misremembering, but well, yeah.
Senator Paholski.
I just want to make sure, Attorney Jones, that you're aware that the International Police Training Agency has spoken out in opposition to deceptive interrogation practices, and many other countries have already banned this.
And as to juveniles and as to the other laws that have been passed regarding juveniles, that meaning under age 18, there's no real dispute there or no concern there, to the extent that S6 had the original intent of modeling off of essentially any other statute passed in any other state. There wasn't much concern from the Department of Public Safety about that. And we took a conciliatory approach from the beginning on this bill because of that. It's really the concerns that the expansion of this bill beyond the laws provided in other states. That's really where the concern comes from.
But that didn't expand in the House. We did that work on the Senate side.
I'm aware of that.
Yeah,
Okay.
on the,
18 through 21. That hasn't changed in the House version. We did that here. So it seems clear that we had the intent of expanding it.
I think I have I can't read their name, so
Daniel Erb.
please go ahead.
Thank you. For the record, Nathaniel Erb here on behalf of the Innocence Project. Thank you for considering this legislation again. So I wanted to testify on a couple of the issues that have been raised. Certainly, I understand that Vermont would be the first state to move above 18 to 21. But as the good senator mentioned, the International Association of Chiefs of Police have already said juveniles undefined as an age range, just juveniles as a concept, deception shouldn't be used against them. And there's been discussion of testimony that was heard in the House side that wasn't heard by the Senate side. And two of those people that also didn't testify on the Senate side was the new head of the Office of Child Advocate for Vermont, who testified fervently that the age shouldn't be lowered and encouraged the committees to continue to adopt that higher age of other states. Additionally, another person that testified is Mark Fallon, who is the former training head for the IACP. He also was one of the lead trainers at the Federal Law Enforcement Training Center, and a part of the group that originally identified the modern training techniques for the high value detainee task force of federal government, which tackles the most serious crimes of terrorism and threats to bases across the country, and fervently testified that deception for all ages is.
This is not a unicameral legislature, and the House seems to think it is lately. And I'm a little pissed about it, to put it mildly. And so, the fact that we didn't get testimony and hear from somebody is immaterial. We didn't have the opportunity. This all came up later. And so while I may fully support the 18 and under, which is similar, and your letter to the committee this morning or yesterday, we're in line with Utah and other states that have passed this law on an under 18. I'm really concerned about their pushing forward in other age groups without us having testimony. Yes.
Ella Chapin, Representative East Montpelier on the House Judiciary Committee. And I would just love to add a little clarification.
No. The House Judiciary Committee has been, all right, go ahead.
I want to say that we did hear the testimony that Tucker Jones is referring to. And one thing I want to clarify about what he just shared is that we definitely heard many people talk about the kinds of questions they ask in custodial interrogations, and that those were not, we actually heard specifically that they were not sort of posing, we have this evidence, what do you say about that? They were more, if we had a kit from the nurse that might show DNA, what do you think would be in there? So they were more this suggestive. So I just want to clarify that that is what we heard from many law enforcement officers and investigators routinely, which was on the edge, which does not fall in the deception language as you built here in the Senate committee. And then I just wanted to explain again and reiterate, I think what Michelle was trying to get at, which is that we took what you did around banning deception and threats and physical harm for under 22 and having this language around how to overcome the, overcome the presumption in court. And we broke that out and we left what you did for the 18 to 21-year-olds, because what we heard was that is a group, particularly around sexual assault on college campuses or in that age range, is one of the few places where this borderline deception questioning particularly is necessary, because there is not evidence, there are not witnesses. So we left what you did around 18 to 21-year-olds because we thought what you did worked for that, and still gave law enforcement an avenue to ask some potentially deceptive questions that then could be overcome in the court. What our committee did, because we had a number of folks who wanted to just ban deception altogether, is we decided, based on all the testimony we heard, nobody was really saying we use this in children and it's a useful technique with children. So we banned it outright with no opportunity to overcome the presumption for under 18. So that's the only change we made to this section in the end.
Okay, thank you.
Oh, sorry, other than taking harm and physical threats, which it took us a while to even realize was packaged in there. And when we realized that, we did make a presumption that you probably didn't intend to allow physical harm and threats, because they're basically not allowed in our state anyway.
Right.
So we clarified that, which we thought we might cover with.
Thank you for that. I appreciate the explanation. It's helpful to have your clarification. And I apologize for my comments about House Judiciary. On another issue, they're very real. I've gotten emails from the Commissioner of Public Safety through Attorney Jones. I've gotten emails from the Chiefs of Police Association, emails from the police association, not the chief, but the police. Very concerned about this bill. I don't know, the changes from the House. So I don't know if there's anybody else that wants to speak on it, either Jen or Marshall. Speak on the changes. In terms of the victims community, are there concerns?
Jen Pullman for the record, Constant for Crime Victim Services. I do think, in my previous work, I was the director of the Vermont Children's Alliance, which oversees the child advocacy centers and special investigation units in the state. And there, to a person, there was opposition to what this bill in terms of how it felt that it would impact their work and their ability to protect young victims and especially children. And Samantha Prince did speak to that in the House Judiciary, and I think it's unfortunate that she didn't present in the Senate because this special investigation units, and you were obviously the part of making sure those were in each county, do a great job of really training, and that's where those if questions come out. So it modulates the way that those questions are asked, and I have a lot of confidence in the way that they're doing their work because they are highly trained. Directors have forensic interviewer training, and I think that piece and that model is great. But to a director in every county, they were really concerned about how this would play out in terms of sexual assault and sexual abuse cases.
Is that, can I ask a quick question? Is that with the House changes or with the original bill?
That was with the original bill. There wasn't time in the Senate for Ms. Prince to speak, but
okay.
She is from your county, and I could ask her to follow up with you individually, but she wasn't able to present on behalf of the Special Investigation Unit directors in the House.
Does she have at the state's attorney's office?
No, she's an independent director and forensic interviewer who oversees the nonprofit CAC and also is the director of the SIU, but she is not a state employee.
Oh, thank you.
I have, I just sent to Peggy a copy of an email from the Vermont Association of Chiefs of Police, and they have a letter that will be posted on our website of concern about the bill, the House changes.
I just wanted to, I don't mean to beat a dead horse, but I feel like sometimes it's getting mixed up. I just want to clarify that the House didn't make any changes to how you treat deception for 18 to 21-year-olds. It's the same in the Senate proposal and the House proposal. There's no difference. So if the primary concerns from, and I haven't seen all those letters, but if the primary concerns are about that and creating a presumption that deception, creates inadmissibility for 18 to 21-year-olds, and then it gives the criteria for the state being able to overcome that presumption. So it doesn't mean that it can't entirely. So there's an opportunity there for the state to overcome that presumption. Again, that's the same in the Senate and the House version. There's no difference for the 18 to 21-year-olds.
Yeah, a lot of the opposition stuff that I've been getting is opposition to the underlying bill that we already passed. It is actually not opposition to the changes that have been made. So
Correct.
It sort of feels like people are coming back for one more chance to.
I mean, the amount of opposition seems substantially higher than when we first took it up.
Well, that's common. People realize. I mean, that's common when a bill passes the House and gets to this committee, we start to hear comments that we didn't hear because they think we're going to pass it, vice versa. Michelle, you have your hand up again. Oh, took it down.
No, she don't.
Do we actually have this bill in our possession?
Not yet,
Okay.
but we're going to have it.
Yeah,
We need to make a decision whether to ask for a committee of conference, concur. I don't think we should concur with proposed amendments. I don't know if they do.
So you'll probably get this bill next week. Because like I said, it needs to still go to appropriation. So I assume that they will do that today. So you wouldn't see it till probably the middle of next week, depending on how they advance the calendar.
You know, this is a real problem this year, and I don't know how the pro tem and the speaker are gonna deal with it, but there's a lot of bills that are gonna be where the other body doesn't have an opportunity to respond. It's either yes or no. Because if it's not till the middle of next week, we don't have time to have a conference committee. But Saturday
I support the changes the House made. I'm sure this comes as no surprise.
comes as no surprise.
I would vote to just concur.
I wouldn't.
I like to dwell on things, but
I don't think it's time to concur on this.
No, I don't agree with that.
So, yeah, I mean, it's not my fault that, you know, these bills are being held up till next week when we're supposed to adjourn next Friday. I can't control that.
Do you really think that's gonna happen? I don't feel like we're in any position to be adjourning next Friday.
I hope it happens.
Well.
There's so much work still to do.
I'm looking forward to the commute to Bennington every day because I lose my apartment on the 15th. No, we're not adjourned. I'm sorry.
That's right. Just checking.
Yeah, I want two other things. One is H53, the DLS bill.
Mhm.
The Senate Finance Committee is still looking at that and wants more time with it. But I think they're tending to say that a fee shouldn't be, they're not necessarily opposed to getting more money to the network, but that it's kind of inappropriate to have the fee as part of the DLS bill and then put marriage into it. So that's the latest from Senator Cummings, and it's really up to that committee.
So there is a bill, S-476, that already deals with that fee a little bit. That's in appropriations right now that came out of Senate GovOps. Do we want to flag that for finance as a possible place to move that?
I suppose I could.
Because that deals with domestic and
But
sexual
then if we
violence.
raise a fee there,
It just seems like it might be a better fit given that we're already dealing with that
well, yeah, that
fund
would be a
in the
better
bill.
fit. Yes, absolutely. But I leave that up to, I mean, if the finance committee says no on S53 to stripping it, then we'd have to concur with further proposed amendment to strip the fee.
Right, and I guess what I'm thinking is, given that there's a bill sitting in appropriations right now, that might be a better place for it, that
Yeah,
might
That
ease the
may
wheels
be,
for the
but I
House.
think we better, we'll wait for the finance committee to let us know. That's
Okay.
why we're gonna pass over 53. And it's okay with everybody if I order S-227 to lie until we can hear from the Franklin County Bar.
Sure.
The power of attorney.
That's,
Yeah.
yes.
Yeah, that's fine.
Those are the only, and we have H45 on notice. I think.
It is.
And then we have, what else do we
S33.
Piece of litigation is 45, you're doing that one?
No, Senator
I'm-
Steers is doing that one.
have? I'm doing,
33 is miscellaneous judiciary.
S-33 is a miscellaneous bill, and I don't think there's anything dramatic in there. But we'll always wait and see.
S89, right?
Pardon?
S89?
What's S-89?
Forensic facility.
Oh, I don't know where that's at. Are they still, are you still debating that? It's still in your committee. Thank you.
And
Yeah, I don't-
91 is on notice.
Pardon?
S91
Yeah,
is
no,
on notice
I
as
think
well.
we're pretty much okay with
Okay.
S-91. right?
Except I was gonna wait to see if we were gonna add someone to the study committee.
Oh, that's right, yeah, yeah. Concur with further proposal, just add more.
I'm just waiting to hear back from the folks that I reached out to as to who that should